Senator Johnson.
Thank you, Madam Acting Deputy President. Well, this is a very interesting piece of private members' legislation requiring agencies and ministers to publish the exact wording of Freedom of Information requests or the answers thereto. The amendments, as I understand them, in the brief time that I've had to review them, will also require agencies and ministers to publish a statement of reasons concerning the decision to allow or refuse the release of requested documents. And of course, Madam Acting Deputy President, whenever someone is asked to present reasons, clearly those reasons will be the subject of judicial review at some further point in time or pursuant to the review provisions contained in the Freedom of Information Act. Asking ministers to provide reasons which will be the subject of review is a very, very heavy burden, and one which should not be undertaken lightly in terms of increasing and exposing the executive to legal process. The bill will and has the stated aims of ensuring transparency and accountability, requiring transparency and accountability to be included within the framework of government decisions concerning freedom of information requests, allowing the public to view requests that have been made and the reasons why documents were or were not released. Now, can I say that the current situation, as the law provides for today, allows for just that. Now, thirdly, it allows for applicants seeking similar documents to build upon previous requests, seeking to reduce duplication of requests. Now, all of these appear superficially to be quite laudable objectives. One has to ask the question, given that the opposition were in power for 6 years in Australia, from 2007 to 2013, why these amendments and changes were not brought forward then. I think I have a bit of an inkling as to why that was, because transparency was not something that was high on their agenda at the time, and indeed one just momentarily needs to reflect on the modelling for the carbon tax and how that was unavailable to any members of parliament or to the public, and was continually denied in supporting the financial workings of that carbon tax. So 6 years, no change, no transparency under Labor, and now we have a private members' bill that seeks to put an enormous administrative burden upon the government of the day, namely the Turnbull government. Section 11C of the FOI Act currently requires agencies and ministerial officers to maintain an online disclosure log. The disclosure log must either publish information made available in response to an FOI request or provide details of how the public may obtain that information. Providing details to the public as to how to go about obtaining the information is a standard, stock standard, usual and understood methodology in the accessing of government documents. Why would you want to muck around with that? I think that's a bit of a mystery that the good Senator Ludwig needs to explain to us. Now, Senator Ludwig's bill proposes to amend these requirements by removing the option of providing details on how the public may obtain the information. That seems to me to be a very retrograde and backward step. The bill is entitled Freedom of Information, and yet we're not going to tell the public how to access that information. Secondly, it requires the publication of existing wording of the FOI request, and thirdly, requiring publication of a statement of reasons concerning the decision to allow or refuse the release of the requested documents. And I've said something and dealt with the matter of providing those reasons. Now, Madam Acting Deputy President, the current disclosure log requirements, together with the Information Publication Scheme, or IPS as it's called, were part of the previous Labor government's package of FOI reforms in 2010. These reforms were intended to reduce the number of FOI requests over time, with the FOI Act providing access to information through agency-driven publication rather than only in response to requests for documents. However, the Hawke FOI review found that the implementation of the information publication scheme had, strangely, the completely opposite effect. That is, instead of making things easier, more accessible and more transparent, the IPS and disclosure log requirements in many cases increased the FOI processing costs, with resources being diverted from other key areas to assist with FOI processing. And of course, Senator Ludwig has a very illustrious record of asking page after page of quite superfluous questions at both Senate estimates and in FOI requests. As well as increasing the costs of FOI processing, these initiatives have not resulted in any reduction in the number of FOI requests received by agencies and ministers. So the unintended consequences of the Labor Party's former reform measures of 2010 actually achieved, in my understanding and in my argument, Madam Acting Deputy President, the opposite of what was intended. It became more process-bound, it became more costly, and it became more difficult for the government of the day to respond and answer the FOI requests, which is, I would have thought, completely contrary to what was intended. Similarly, this private member's bill, I think, is going to exacerbate the situation very clearly because it simply has not been thought through properly. And indeed, if it has been thought through, I think it has an ulterior motive to it. In fact, since FOI reforms commenced in 2010, the number of FOI requests have increased from 23,605 in 2010-11 to 28,643 in 2013-14. Now, I note, Madam Acting Deputy President, that the bill seeks to change the definition of working day. I find that very interesting and a little incongruous. Working day has a common or garden variety meaning in the minds of most normal people. A working day is a day where people are actually working. And I think, Monday to Friday is the Interpretation Act's assessment of what is a working day, in my understanding. It's only used once in the legislation, in section 11C. It's very difficult to see how a change or an artificial, contrived definition of the words working day will eliminate confusion concerning timeframes for publishing information. I think, as is usual with legislation that hasn't been thought through, this will be even more confusing. Where are we at? And accordingly, it's a significant flaw in this legislation. It provides for unintended consequences, which is rather typical of the sort of half-baked legislative understanding that comes to this place from the Labor Party from time to time, only rivalled usually by that of the Greens. So, in items 2 and 3 of Senator Ludwig's bill, they remove the option. They remove the option for an agency or minister to publish details of how information may be obtained rather than the information itself. Currently, section 11C subsection 3 provides that the information disclosed in the request must be published on the agency or ministerial website by firstly making information available for downloading from the website, and that's section 11C3A, and secondly by publishing on the website a link to another website from which the information can be downloaded, which is in section 11C3B, or thirdly by publishing on the website other details of how the information may be obtained, and of course that's found in section 11C3C. Items 2 and 3 of the good Senator's bill amend section 11C3 to remove the option of simply publishing on a website details of how the information may be obtained rather than the information itself. I must say I find this legislation and the intent behind it very, very vexing and troubling. Why would you want to close off an avenue for members of the public to find and access further information? This is very, very peculiar. and I'm not sure what the good senator's intentions are here. Senator Ludwig states that this amendment is designed to provide the public with easy access to documents released under the FOI Act. The current requirement is for information to be released is to be published to the public generally on a website. Some agencies publish the documents released on their websites together with the FOI requests. What this will do is remove the flexibility where the information cannot be readily published on the website of providing details of how the information can be accessed. And so references to the Australian Bureau of Statistics, references to other annual reports where there is a wealth of other information, all of those sorts of things apparently cause some angst to the senator in the presentation of, and motivate him to present these amendments. I must say I find all of that very, very confusing. It may not be straightforward for an agency or minister to publish some documents in accessible formats on a disclosure log or to convert documents to such formats within 10 working days. And of course, those difficulties and disabilities are not addressed in the legislation, as one would expect. The details haven't been considered. May I say, using a colloquial, the whole thing is a bit half-baked. This may be an issue, for example, if information has been redacted from a document or where the voluminous nature of the document is only available as a hard copy or in a PDF format. So removing flexibility will impose an administrative burden on agencies and ministerial officers in preparing documents for publications within 10 working days of information being released. This could create challenges for agencies and ministers in managing increased FOI workload, and I come back to the numbers that I gave previously. We started off with the Labor Party's amendments with 23,605 FOI requests in 2010, and the amendments have generated an increase to 28,643 in 2013-14. And as I was saying, these amendments are going to generate challenges for agencies and ministers in maintaining an increased FOI workload and impact on the processing of FOI applications. And of course that all converts to one thing: cost. That we all know on this side of the chamber that the very last thing the Labor Party ever thinks of, and its senators ever think of in legislation, is the cost. They have absolutely no regard for the respect required for taxpayers' money in these crazy schemes that they seem to want to implement. Item 5 of Senator Ludwig's bill amends the FOI Act to insert a new provision, new section 11D. This proposed new section requires agencies or ministers, firstly, where access is given to the whole document, to publish the FOI request itself and the reasons for decision within 10 working days after the person is given access. It also requires, secondly, where access is given to an edited document, to publish the FOI request itself and the notice that an edited copy has been prepared and grounds for deletion within 10 working days after the notice is given. And if a request for reasons for decision is made for the refusal of the whole document, publish the reasons within 10 working days after the reasons are given. And thirdly, where access is not given to a document at all, to publish the FOI request itself within 10 working days after the decision and the reason for decision within 10 working days after the reasons are provided. Essentially, this provision will require agencies and ministers to publish the exact wording of FOI request. And if someone has ever seen some of these FOI requests, they go on for page after page after page. New section 11D will also require agencies and ministers to publish a statement of reasons concerning the decision to allow or refuse the release of requested documents. Section 26 of the Act currently provides for statements of reasons to be given where a decision is made to refuse access. So whether you grant or refuse, it appears that you will have to provide reasons as to why you're granting. Section 22 provides reasons to be given where an edited copy of the document is provided. The difference with the new provision is that a statement of reasons is also required where access is granted in full. And I would have thought that is completely ridiculous and quite stupid, may I say, Madam Acting Deputy President, but what am I supposed to expect here? And that all statements of reasons, as well as the requests themselves, must now be published within 10 working days. Now, what that means, given the change of definition of 10 working days, I'm not sure. I think we're all left to wonder why we're taking the definition of 10 working days and turning it into something not readily understood. But 10 working days, if it was 10 Monday to Friday days, 2 weeks, is still not a lot of time. Once again, this new provision will impose a substantial administrative burden on agencies and ministerial officers, which could result in significant process delays in other aspects of FOI processing. And of course, that's something which the good senator has completely ignored. Senator Ludwig states that this measure will facilitate more practical use of freedom of information requests, will reduce duplication of requests and open the door for further reform by parties other than the initial applicant. Well, I'd like to see that because, as I've said, having tried once at reform, we now know that those reforms and their unintended consequences made the process more difficult, more expensive, more schedulally challenged, and generally achieved objectives in complete opposition to what the original intent of those reforms were. And once again, the Labor Party lived up to everybody's expectation that they really have no idea what they're doing when it comes to reform. It is more likely that publishing reasons for decisions will result in overburdened agencies struggling to manage increasingly heavy FOI workloads, taking shortcuts and adopting published reasons rather than making a decision based on the circumstances of each particular request. And I think that's a very logical and likely outcome which I would emphasise to anybody listening to me speaking now. So in conclusion, the government is committed to transparent, accountable and open government. The FOI Act is an important accountability measure that facilitates the open and transparent operation of government and the dealing with individual proprietary rights and privacy matters of people from time to time, as it must in carrying out all of the heavy burden of the day-to-day activities of good government. Rather than ensuring accountability and transparency, the measures in this bill will compromise the effectiveness of the decision-making process under the FOI Act, and of course compromise in a very, very substantial and big way. It is very unlikely that measures in the bill will reduce duplication of requests, as requests cannot be refused where information is publicly available free of charge, or where information that would substantially address the subject matter of the request is regularly made available, e.g. in annual reports or otherwise, and I've dealt with that. So nor can a request be refused if the request is substantially the same as another FOI request that has already been made, so that every second day of every month of every year you can ask for the same information because it inconveniences the government. That, I think, is the nub of what this might be all about. So an applicant does not need to provide a reason for making an FOI request. So what we're doing is we're opening the floodgates to some form of process here that is designed to stand on the hose, to be expensive, to cause the government of the day a lot of administrative woe and problem. Now that's all very well, but you know, I think at the end of the day, ordinary citizens of this country need to have the government of the day working in a cost-effective, efficient manner and not completely focused on the process of FOI requests. These amendments, this bill will not reduce duplication of requests. They will not reduce the number of requests made for FOI, as has been clearly set out that their reforms failed to deliver. Notwithstanding they expressed an intent to reduce the number of requests, those requests have increased. Instead, they will impose further unnecessary steps and procedures into existing process for access to government information under the FOI Act. This will increase the cost, as I've said. It will increase the complexity of FOI processing. And remember, FOI is for ordinary citizens. They're not lawyers. They simply want information. And so this bill is seeking to increase the costs associated with processing that and increase the complexity and result in significant processing delays. Now, I would have thought, Madam Acting Deputy President, that was completely in opposition to what we in this place should want to do. And it's a mystery to me why a senator of Senator Ludwig's standing would want to come forward with such a nonsensical, stupid bill. Thank you.